Welcome to BRR Media. Today I'm joined by Robyn Glindemann, who's a special counsel in the Environment and Planning team specialising in native title here at Allens in Perth. Robyn, it's been 20 years since the basic principles of native title were handed down in the High Court in the Mabo decision. Since that time, what are the key developments that have occurred in native title law?
Well, there's been quite a few. And probably a half a dozen really key ones. The first one was the WIC decision a few years later, which really changed what we understood about pastoral leases and how they affected native title. And the WIC decision was responsible for the huge raft of changes that came in 1998 to the Native Title Act and really changed the way the Native Title Act worked. We also had the Fijo decision involving the Larrakia people in the Northern Territory, and that confirmed that extinguishment of native title really meant extinguishment forever, and that was a very important step forward for us. Also in the Northern Territory, the Croker Island decision developed our understanding of how native title worked offshore, which the Mabo decision really didn't do. And then also the Yorta Yorta decision in Victoria was really the benchmark for describing or prescribing how native title claimants had to prove their claim and what they needed to bring to court to show the connection required to land, which was one of the original principles in the Mabo decision.
How do Australia's native title laws compare to other jurisdictions such as Canada and New Zealand?
There's a lot of similarities actually between the jurisdictions, which people don't often recognise, but probably the main difference is the fact that in Canada you have constitutional recognition of Aboriginal and treaty rights. It's 30 years this year since the Charter of Rights and Freedoms came into effect in Canada. And Section 35 of the Charter protects and acknowledges Aboriginal rights and treaty rights in that country. So that's a very important difference. New Zealand, of course, has the Treaty of Waitangi, and that really frames the relationship between the Maori people and the non-Maori people in New Zealand. And each jurisdiction also reflects the cultural differences. There are differences innate between native title in Australia, between the native title rights, if you like, of the Indian people, the First Nations people in Canada, and again in New Zealand. So those differences have to be reflected in the laws that we have. Canada, in some respects, is very similar to Australia, particularly Western Canada. Western Canada has no real treaties. So in many respects, Aboriginal rights there are the common law rights that are recognised by the court, which is of course what we have here in Australia. And so there is a great deal of similarity, and in fact the courts in both Western Canada, particularly British Columbia and Australia, have referenced each other in decisions on Aboriginal law because our principles are the same, and because of course we all go back to the British Crown. So those are the main differences, and the other difference too in Canada is the Indian Act, which is a federal piece of legislation that came into effect in the early 20th century, and that has also framed the relationship between Indigenous people and non-Indigenous people in Canada, and we don't have any equivalent to that here in Australia. But that said, the Native Title Act here is purpose-built for the situation we have in Australia, but also delivers results. It's not without its problems, but no jurisdiction is perfect in how it manages its relationship with Indigenous people. So each jurisdiction has its own advantages and disadvantages.
Which sector would you say of the Australian economy has been most affected by native title, and how has that sector responded to that?
Well, it's a tough question. I think really every sector of the Australian economy has been affected by native title. It's just a question of degree and what that effect has looked like. It's probably fair to say that the hard rock mining industry has been the most visible in both responding to native title and also addressing it as part of project development. And certainly many of the examples, particularly in relation to agreement making, voluntary agreement making with native title claimant groups, a lot of that work has been done in the hard rock mining sector, and that's been the way to respond to the challenges that native title presents. The changes to the Native Title Act in 1998, which introduced the concept of the Indigenous Land Use Agreement, were really key in facilitating the relationship and the response, particularly of the mining industry. In Queensland, for example, there are over 600 Indigenous Land Use Agreements, and that's in all sectors of the economy, but there are a lot of significant agreements in the mining sector. And of course, here in WA, you've got the response by Rio Tinto and BHP Billiton, as well as a lot of other mining companies in the agreement space, and that's really been a great step forward.
Robyn, I understand there are a lot of native title claims that are yet to be resolved. Why has it taken so long to resolve these claims, and what can be done to reduce the backlog?
Well, we have to remember that solving native title or resolving native title claims is a very complex process. So we're not dealing with a straightforward litigation. It's a very complex litigation process that we're asking parties, both native title claimants, state governments, the federal government, and all of the stakeholders involved to participate in. And so that takes time, and we need to be patient. There are still lots of native title claims that need to be resolved, but we have to remember firstly that we're asking people to go back over 100 years of history, and to sift through those records, assuming they exist, it's not electronically searchable. So it takes time to physically turn the pages and find the information that the court requires native title claimants to find. Secondly, we're dealing with lots of stakeholders, and they all need to be heard. And that takes time for them to present their cases to the court or in a mediation context. And thirdly, you need experts to be able to sift through the information and to present it in a manner that the court can digest. And there are only so many archaeologists and anthropologists around who have the experience, the skills and the trust of the native title groups to be able to take their claim forward. So with all of those factors, it's going to take time, and to solve that problem, the main question or main issue is patience. We just need to be patient. And I compare it to the Nisga'a people in British Columbia, Canada. It took them 113 years to have their claim to their land resolved. So a few decades in Australia is really not that long.
Robyn, thank you.
Thank you very much. It's a pleasure.